This is in reference to the Supreme Court. Now, I want you to see this because Workers Strike Back actually tweeted this out. The Supreme Court just ruled 8-1 in favor of the bosses in the anti-union case Glacier NW versus Teamsters. The court majority, including Obama appointees, have shamefully made it easier for bosses to sue unions for the economic losses to businesses when workers go on strike. Let me highlight this piece right here. Including 2 Obama appointees. And that just reiterates what I've continued to tell you over and over again, which is that it doesn't matter what political party they're a part of. All of them back capital. All of them back big business. And in this particular case, the Supreme Court justices, except for one, all agreed to back big business over the workers. Why is this important? I'm going to get into the details in just a second. This is important because as much as I have been a supporter of unions, a supporter of trying to unionize, I've continued to tell you that at the end, that should not be the end game. The ultimate goal should be worker co-ops. And this case in particular is a perfect example of why we need that to happen. So I want to go to this article here from NPR. Unions are relieved as the Supreme Court leaves the right to strike intact. First of all, shame on you to NPR for even leading with such a BS title. This is NPR trying to make a bad thing sound like a good thing. Just because the Supreme Court didn't take away the right to strike, that doesn't change the fact that they ruled in favor of big business against the workers, and the workers can still be penalized for going on strike. So shame on you to NPR for even leading with this whack ass title. You should have known better. Let's go on. There's the Supreme Court there. By an 8-1 vote, the High Court ruled against unionized truck drivers who walked off the job, leaving their trucks loaded with wet concrete. But it preserved the rights of the workers to time their strikes for maximum effect. You see how they're phrased, how they're wording this? They don't want you to think that this is still an injustice that's done to the workers. Virtually every strike is based on timing that will hurt the employer, said Stanford Law School professor William Gould, a former chairman of the National Labor Relations Board. And there was a great concern that the court would rule broadly to limit the rights of strikers. But that did not happen, he noted in an interview to NPR. You see how this is going? At first glance, the Supreme Court did seem poised to issue a decision more damaging to unions. Thursday's ruling followed 3 earlier decisions against labor in the last 5 years, including one that reversed a 40-year-old precedent. And the truckers' case posed the possibility that the court would overturn another long-standing precedent dating back nearly 70 years. So labor feared the worst, a decision that would hollow out the right to strike. Thursday's decision, however, was a narrow ruling that generally left strike protections intact. Look at the vocabulary. Generally, narrow. This is to make it sound like it was less of a blow than what it was. The case was brought by Glacier Northwest, a cement company in Washington state, against the International Brotherhood of Teamsters. After the union's contract had expired and negotiations broke down, the union signaled its members to walk off the job after its drivers had loaded that day's wet concrete into Glacier delivery trucks. The company sued the union in state court, claiming the truck drivers had endangered company equipment. Wet concrete, it explained, hardens easily, and the company had to initiate emergency maneuvers to offload the concrete before it destroyed the trucks. This is an example here that just shows you had endangered company equipment, that these companies and the Supreme Court care more about property than people. Let that sink in. They care more about property than people. Because you see, property can be replaced. And I find it very hard to believe that a company like Glacier Northwest can't replace the property, can't replace equipment either. I hope everybody sees the writing on the wall with that. But the Washington Supreme Court ruled that Glacier's complaint should have been filed with the National Labor Relations Board. For nearly 70 years, the Supreme Court has said that federal law gives the board the authority to decide labor disputes as long as the conduct is even arguably protected or prohibited under the federal labor law. The business community was gunning for and hoping to eliminate that rule, but it didn't get its way. Again, see how they're trying to frame this? They're lying to you in this article by making it seem like the business community didn't win here. This was a win for the company. The Teamsters Union lost. And so here's NPR. The business community didn't get its way. My, how the mighty have fallen. I remember NPR used to actually be good. This was a case of winning a relatively minor battle, but losing the war. The High Court did not overturn or otherwise disturb its long-standing rule, giving the NLRB broad authority in labor disputes, leaving unions free to time when they will strike. Here's the problem. Leaving unions free to time when they will strike. Why would they not be free to do that? Let's stop pretending like this is some bonus that was given to the union. You should be able to do that regardless. Oh, but it ruled in their favor. They didn't win, but it's okay because it gives them the ability to be free to time their strike. You're supposed to be able to do that anyway. You know, it's like, I hope people can read through the lines with this article. At the same time, the court's majority decided the case in favor of the company in a very fact-specific way. I'm going to show you who wrote this article in a second. This is a hot mess. Very fact-specific way. The court ultimately said the union's conduct in this particular case posed a serious and foreseeable risk of harm to Glacier's trucks. Again, risk of harm to Glacier's trucks. Once again, showing you they care more about property than people. And because of this intentional harm, so let's pretend there was no intentional harm that was done to the people. That's why they walked off the job. Because of this intentional harm, the case should not have been dismissed by the state Supreme Court. Though the court's vote was 8-1, breakdown of opinions was more complicated. Here we go here about the justices. Yada, yada, yada. The court's 3 most conservative justices wrote separately to express frustrations that the court did not go further and reverse a lot of the protections for striker rights. Justice Alito virtually invited Glacier or other businesses' interests to come back and try again. You guys see this? Writing for the dissent, Justice Ketanji Brown argued the union acted lawfully in timing its strike to put maximum pressure on the employer, pointing out that Glacier could have locked out the workers or had non-union workers on standby in the event of a strike to prevent any surprise strike timing. There are 27 cases still to be decided by the court as it enters what is usually the final month of the court term. And many of those cases will be highly controversial. In Thursday's case, though, the court quite deliberately took a pass. If there is to be a major retreat on long guaranteed labor rights, it will not be this term, and labor leaders were relieved. You see this? Relieved. Labor leaders were relieved. Now, does this sound relieved to you? The court majority, including 2 Obama appointees, have shamefully made it easier for bosses to sue unions for the economic losses to businesses when workers go on strike. And this is exactly why, you see what I mean? They can sue you now. This is exactly why unions cannot be the end game. And I like Workers Strike Back. I love the things that they're trying to do, creating a workers movement across the country. I went to the Workers Strike Back launch here in Boston. Totally get it, totally support unions. But even there, one of the things that I said is that this needs to develop into worker co-ops. Now, I didn't get to speak there because I got there a little bit late. But in talking to people, that's what I said, like worker co-ops should be the end game. And this case that just happened here with the Supreme Court is a perfect example as to why unionizing should not be your end game. That's a great first step. But the end game should be a worker co-op so that you own it. The Supreme Court can just come in and make decisions on behalf of the company and support the company. They are not going to back the workers. Because again, what this case has shown you is that they consider property to be more valuable than people. So they are not going to decide in the workers' favor. And since you don't own the company, you're a part of the union, but you don't own anything. You don't own a piece of the company. You have to go along with the company's rules, or you have to go work somewhere else. And this is why it is incredibly important that once you do the unionizing part, you move on to that next step, which is turning these unions into worker cooperatives. And that should be the end game. It's not enough just to start a union. And I'm sorry, I know some people disagree with me about that, but I'm going to keep it real to you. Look at what just happened. The way that they can just come in. And you can betcha, going forward, there's other cases. Going forward, they are going to side with the company because, again, they back big business. They back the businesses that back the property, and neither one of them back the people. And that's how it works. So one of the reasons why I continue to tell you, check out Democracy at Work. Richard Wolff, Democracy at Work. They have a whole website and a whole channel where they talk about worker cooperatives. They have a whole step-by-step process on their website where they explain to you how to do it. But we should never just get to the point where we're like, yay, we have a union, woohoo. Because look at what happened with some of the Starbucks stores. They formed a union, and then what? Then what? Howard Schultz and them came in and said, okay, we're going to close down this location. Now what? And there's nothing you can do because you don't own it. And that's the big difference. We got to talk more about this on the show. We got to talk more about it because it's very important, you guys. Don't sell yourself. I don't want to say sell yourself short, but don't just get to that point and say, okay, this is it. This is good enough. I'm all right. Because as soon as you're just all right, you see what happens. And Teamsters have been around for a long time. Also speaks to another issue is where we need to take some of this power away from the Supreme Court.